Good morning. My name is Duff Conacher. I am co-founder of Democracy Watch. And Democracy Watch is one of Canada's leading democratic reform, corporate responsibility advocacy organizations. I am here today to announce that Democracy Watch is taking the next step in its years-long process to hold the Trudeau government and Prime Minister Trudeau and the Trudeau Cabinet accountable for pressuring the Attorney General back in the fall of 2018 to intervene and stop the prosecution of SNC-Lavalin. And Democracy Watch has chased after the RCMP right back since these revelations were made in February 2019, filed access to information requests and pushed on those requests, and has had now more than 3,600 pages of internal investigation documents disclosed by the RCMP. And what those documents show is that the RCMP did a weak, incomplete investigation. They only interviewed 4 of 15 key witnesses, and they trusted the public statements of everyone involved in pressuring the Attorney General, Jody Wilson-Raybould, at the time. And they also changed the standard that they used for determining whether there had been an obstruction of justice, using an incorrect legal standard for making that assessment. They also essentially didn't give any updates for years. And as I mentioned with our access to information requests, we had to pursue them and finally got full disclosure after more than 2 years of the internal investigation records. As well, the RCMP essentially characterized everything that the people said who were involved in pressuring the Attorney General from the Prime Minister on down in a favorable way, while doubting the claims and constantly essentially tilting the investigation in favor of not prosecuting anyone, and then made a secret, behind closed doors and very questionable decision not to prosecute anyone. Given the evidence, and given as well that the RCMP did not apply the correct legal standard in terms of reviewing the evidence and determining whether there had been an obstruction of justice, and also given that the RCMP did not consider in its investigation whether the Prime Minister or anyone else had committed a breach of trust, Democracy Watch is today filing an application in Ontario Court of Justice for court approval to pursue a private prosecution of these allegations of obstruction of justice and breach of trust. And that's what I'm here today to announce. And Democracy Watch's position has always been during the investigation that the RCMP should not have been investigating this matter, should not be investigating any matter involving federal cabinet ministers, because the RCMP commissioner, the deputy commissioner, and the heads of every division of the RCMP are all chosen by and serve at the pleasure of the Prime Minister and the Cabinet. And as a result, they lack independence and are vulnerable to political interference. And what should have happened is that a special prosecutor should have been chosen, not by the ruling party Cabinet, not by the RCMP commissioner who serves at the pleasure of that Cabinet, but through a fully independent process. And that special prosecutor should have both directed the investigation and also issued a public statement at the conclusion of the investigation concerning prosecutions, and if there was a decision not to prosecute anyone, that would have been disclosed, and obviously if there had been a prosecution, that would have been pursued in court. Another sign of the RCMP's lack of independence and weak investigation in this situation is that the RCMP accepted the Trudeau Cabinet's very restricted order in terms of what cabinet documents could be disclosed to the RCMP for its investigation, and also what Jody Wilson-Raybould, the former Attorney General, and others could say about the situation and the pressuring by the Prime Minister and others who were acting at the direction of the Prime Minister. And what the RCMP should have done, and if there was a special prosecutor who was independent, they probably would have done, is they would have applied to court to get access to those internal cabinet communications, which are obviously key evidence concerning whether the obstruction of justice or breach of trust occurred. So Demarche-Ouatt's position now that the investigation is over is that a judge in an open court hearing all the testimony from all the witnesses and also considering all the evidence would make a decision as to whether a prosecution should be approved and Demarche-Ouatt allowed to pursue this private prosecution. So that's what we are going to be applying for today in the Ontario Court of Justice, and hopefully the courts will recognize and our documents that are filed with the application point out all of the weak and incomplete aspects of the RCMP's investigation, and again, importantly, that the RCMP utilized the incorrect legal standard for determining whether there had been an obstruction of justice. They used a standard that would require that there be a corrupt intent by the Prime Minister or others, and that is not the legal standard for obstruction of justice. The standard is simply that it was willful and that there was intent to do it. So we will be hopefully meeting with the Justice of the Peace of the Ontario Court of Justice today. We will certainly be filing the application. The meeting may come later. And then the process is the Justice of the Peace will decide whether the evidence and arguments that we are putting forward warrant what is called a pre-enquête hearing. And at that hearing, we would present our case in brief, essentially, and that hearing would then determine whether a private prosecution can go ahead. What can happen is that the Attorney General of Ontario, a lawyer representing the Crown Counsel of the Attorney General of Ontario, can step in and take over the prosecution. So that is possible that could happen, and then the Attorney General's office in Ontario would have the discretion to stop the prosecution if they so wished. We hope that that process will also be done through a special prosecutor because the Attorney General of Ontario is obviously a politician from a political party, the Progressive Conservatives, and we don't want the rest of the steps of this investigation and accountability process for this situation to be tainted in any way by partisanship in the way that we believe it has been tainted by partisanship to date. I welcome any questions that you have. Thank you.
In your investigation of this, was one thing that took so long to get the documents, but were you able to find any reason why this is going on over 6 years ago now, why this investigation took so long, especially since they didn't interview all that many witnesses?
Yes. Well, the chronology in brief is that there were meetings very early on with Jody Wilson-Raybould in May of 2019 and September 2019, and meetings with others, not too much after that, initial meetings. But the other witnesses, for example, Jessica Prince, the former Chief of Staff for Jody Wilson-Raybould, was not actually fully interviewed until October 2020. Neither was Jane Philpott, a minister and friend and confidant of Jody Wilson-Raybould, not interviewed till October 2020. The final interview with Jody Wilson-Raybould took place in February of 2020. The Ethics Commissioner report came out in August 2019, which revealed pretty much everything that had gone on, and as did the House Committee hearings. The RCMP is still hiding some evidence in the records we have disclosed. There are statements from Jody Wilson-Raybould, Jessica Prince, and Jane Philpott that have been redacted that when they're answering key questions about what they thought of the situation and whether it crossed the line. which raises serious questions about why the RCMP is hiding those statements. Then what happened was the investigating officer, Sergeant Frederic Penzance, filed his report in March 2021 with the National Command of the RCMP, and then it has not been explained by the RCMP what happened and why they took until January 2023 to make a final decision to not to prosecute anyone. So a year and 9 months went by, and that year and 9 months is a period that has not been explained. RCMP Commissioner Michael Duhem committed to the House of Commons Ethics Committee back in February 2024 to disclose all the internal communications covering that period, and made that commitment in response to a question from an MP. As we disclosed yesterday, the letter that Michael Duhem, RCMP Commissioner, sent to the committee on April 26, 2024 was just over 2 pages and just had a very vague statement about why there had been that delay, and it essentially just said there were other things going on, a change in personnel, and that's why a year and 9 months went by between the final investigation report being filed with National Command in March 2021 and the RCMP National Command final decision in January 2023 to not prosecute anyone. Again, a secret behind closed doors decision that was not disclosed until we finally pushed it out through the Access to Information Act process in June of 2023. Unfortunately, the Ethics Committee gave up and didn't call Michael Duhem back or send him a letter back saying, you committed to giving all the internal communication records, where are they? We probably have a lot of them in the 3,600 pages that Democracy Watch has dug out over the past few years through Access to Information Act requests. But there may be some others hidden, and there is no explanation from the Commissioner. The Commissioner should be asked why he broke his commitment to disclose all of those records to the Ethics Committee when he made that commitment. He made that commitment back in February 27th, 2024.
And if this was to go ahead with an independent prosecution, like you would like, and there was convictions, what could be some of the possible penalties, I suppose, if it did go that far?
The penalties are significant fines and possible jail terms, both for breach of trust and obstruction of justice. So obviously we have to get over the hurdles first of having a court move to a pre-enquête hearing, and then out of that hearing have the court actually issue the warrant and for the charge and the prosecution proceeding, whether it's proceeding with Democracy Watch carrying it as a private prosecution or the Attorney General of Ontario, hopefully through a very independent process, having a special prosecutor carry it forward. And then obviously it would be an open court hearing, like all criminal cases, or almost all. There obviously are some closed court hearings in some national security cases. And then the judge or jury would be deciding whether, what penalty and obviously whether anyone should be convicted. Just to mention one other quick thing about the Special Prosecutor Service. In British Columbia, although the Special Prosecutor is usually chosen by the Attorney General of the province in these kind of cases, at least what happens is that it's not a government lawyer, it's someone chosen from private practice by the Attorney General, and they usually carry these kind of cases when the charge is about someone within the government. It's happened in Ontario as well, and at the federal level, it hasn't happened and should have happened in this case. This should have been handled in a much more independent way, rather than having the RCMP Commissioner, who again serves at the pleasure of the Cabinet and can be fired at any time for any reason, directing this investigation.
Are you are you concerned that because of the passage of time and, as you can see, the perhaps loss of interest even at the committee level to pursue this to the fullest, that I think the Prime Minister's office is probably interested in this going away and delaying, and that they've actually accomplished that goal, and there's been a loss of faith in the system?
Yes, concerning the delay, this is the great Canadian way, unfortunately, and it's why Democracy Watch is also calling today for a new, fully independent anti-corruption police force to be established. Several other experts have called for this for years as well, because the RCMP has done such a bad job, has such a bad record in these kind of anti-corruption cases, also including cases involving money laundering, which is often tied into corruption. And it's just well documented how weak and ineffective their investigations and actions are, in part, again, because they lack independence from the Prime Minister. And we need a new national anti-corruption police force that is fully independent, with a team of fully independent prosecutors. Because what we have is, again, concerning the delay, we have a system where the police often delay things. The government delays giving information to the police in these cases. Years go by and they're hoping that possibly someone will retire from their position or resign, and then the great Canadian way is to let them walk away without any accountability for any alleged wrongdoing. And this needs to stop. Democracy Watch has tracked the overall system. It's very weak and ineffective over the years. International entities like Transparency International have ranked Canada in terms of its overall anti-corruption system, and this recent survey that came out from Transparency International puts Canada at the lowest position world in terms of comparison to other countries that it's ever been at. And it's because of these kind of situations where the world and international entities look at our system and say, this system lets people get away with wrongdoing through delay, secrecy, lack of accountability. Now we're into, with this application, the judicial system, the Ontario judicial system, where the justices of the peace are appointed by the provincial governments, have some independence and are not serving at the pleasure of the Prime Minister. And so we're hoping that the only considerations will be whether the lines were crossed in terms of the legal standards in the criminal code being violated, that there is enough evidence there to have this heard, as it should have been in the first place, heard by a judge in an open court hearing with everyone testifying publicly and all of the evidence disclosed.
Thank you. This concludes the press conference. Merci. C'est ce qui conclut la conférence de presse.
Thank you very much. I welcome your questions. You can contact Democracy Watch at info@democracywatch.ca or myself on my cell 416-546-3443. And I'd like to say that I'm joined here today by Jen Danch from the law firm Swadron Associates, who is representing Democracy Watch through this application process for a private prosecution. Thank you again.